Is a probate bond needed to close an estate bank account? Have you ever wondered if a probate bond is necessary when closing an estate bank account? This is a common question that many people have during the probate process. Let's break it down in simple terms to help you understand what you need to know. First, let's clarify what a probate bond is. A probate bond, also known as an executor's or administrator's bond, is a type of insurance policy. It protects the estate and its beneficiaries from financial loss if the executor or administrator mishandles estate assets. While it is not always required, many courts use it as a safeguard in probate cases. Now, when it comes to closing an estate bank account, the need for a probate bond does not directly relate to the act of closing the account itself. Instead, the requirement for a bond is determined earlier in the probate process. This usually happens when the court appoints the executor or administrator. The court may requiring a bond as a condition of appointment, unless the will specifically waives the bond or all beneficiaries agree to waive it. In some situations, even if the will or beneficiaries waive the bond, the court can still requiring one if there are concerns about protecting the estate. Once the probate process is underway, the executor or administrator will open an estate bank account in the name of the estate. All estate funds are deposited into this account. This account is used to pay debts, taxes, and eventually distribute assets to beneficiaries. Closing the estate bank account takes place at the end of the probate process. This happens after all debts and taxes have been paid and the remaining assets have been distributed to the beneficiaries. At the time of closing the estate bank account, the executor or administrator must provide the bank with proof that the probate process is complete. This usually means presenting a court order or a final accounting that shows the estate has been settled and all funds have been properly distributed. Importantly, the bank does not requiring a probate bond to close the account. However, it will requiring documentation that shows the executor or administrator has the authority to act on behalf of the estate. To sum it up, a probate bond is not needed to close an estate bank account. The bond is a requirement for the executor or administrator to serve in their role, not for the act of closing the account. The bank will need proof that the probate process is complete and that the executor or administrator has the authority to close the account. Understanding these steps helps ensure that estate assets are protected and distributed according to the law.